Hello, everybody. How are you? Now, I will talk about the legal. Just give me 2 minutes and I will start. Only I will wait 2 minutes to start. I will talk today topics. This is our test live stream. Now we stand in the front of the nature, the sea, banana gardens, and the blue sky. And also some farmers there grow some plants. It is very real good weather now. Legal law. Hello, my friends. We have only 2 minutes and we will start. Let's get some coffee and we will start. This is our first live stream here on the Legal Eagle. Now we have some coffee here. The weather is very good. Really, here in our city is very, very, very good.
كنت بستخدمه.
Mhm. I have some flu and cough, but I will do my live stream. Okay, let's start. Let's talk about SAT, Securities Appellate Tribunal. Okay, I want to say some information about that. So I will start now. The function of SAT with only one technical member raises some important legal concerns. Okay, now we will attempt to provide a brief of overview of the situation and answer to the legal concern such as whether the SAT can without judicial member and what is the remedy in cases of extreme urgency in situation where an expert time order is based by Securities Exchange Board of India directing freezing or attachment of bank accounts. Now we have question whether SAT can function without a judicial member. Now I will start again. Whether a SAT can function without judicial member. This is the first question that needs to be answered regarding the function of SAT. In the case of SAT or in the case of State of Jurate Utility Welfare Association, the Honorable Supreme Court of India was faced with questions whether it is mandatory to have judicial mind presiding over state as well as central commissions. As judge, it was held by the Supreme Court that it is mandatory for any bench performing a judiciary function to have at least one person who is or has been holding judicial office, or is a person possessing professional qualification with substantial experience in the practice of law, and who has the requisite qualification to have appointed as judge of the high court or district judge. While deciding the above case, the Supreme Court also made reference, okay, to Section 112 of Electricity Act 2003, which provides for the composition of appellate tribunal for electricity. This decision was followed in the order based by Honorable Supreme Court in the case of KK Agrawal Sanvaj Nadin Sahai, wherein it has been categorically held that any forum commission. However, it may also be noted that in the case of SSCY, the court held that okay, I have technical problem here. I will check it now. Hello everybody again. Now we have another question. Whether state can pass any order without judicial member in case of urgency? Now we will answer this important question. As stated above that, the state cannot function without judicial member. The next question that arises whether it can pass any order in case of urgency where an expert time in interim order is based by SEPI directing freezing or attachment of bank accounts. This question also came up before the Supreme Court in the case wherein that was headed by only technical member. He is Mr. CKG near where passed an interim order directing SEPI not to take any corrective steps against them. However, the Supreme Court disposed of the appeal by observing the sense of justice that has been appointed and function of SAT. In session, all questions on facts and law may be raised before SAT on fixed date. Therefore, the Supreme Court didn't express any view whether any order can pass by SAT in absence of judicial member. Good. Now, let us take another questions. What is the difference between section oh sorry really I want to speak about the fundamental rights directive principle of state policy and fundamental duties. First, to safeguard the interests of people, they must guarantee fundamental rights that are applicable irrespective of religion, rights that are applicable irrespective of religion, caste, place of birth, gender, race, or creed. These are the basic human rights that are not applicable to Indian citizens, but some of them are also available to foreigners. Okay? Now, let us talk about fundamental duties. The Constitution of India illustrates various fundamental duties for citizens of India which are covered under the Constitution of India. It states that it shall be the duty of every citizen of India to abide by Constitution and respect its ideal and institution, the nation flag and the national anthem, to cherish and follow the noble ideas which inspired our nation struggled from freedom. Okay? To uphold and protect the sovereignty, unity, and integrity there. To defend the country and render national service were called upon to do so. To promote harmony and spirit of common brotherhood amongst all the people in the country. Okay? The value and preserve the research. Oh, sorry. To value and preserve the rich heritage of our composite culture. Okay. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have composition for living creature. To develop the scientific timber, humanism, and the spirit of inquiry and reform. Another reason to safeguard. Mhm. Our rights. Okay. Directive principle of the state policy. The directive principles of state policy are the guidelines for the state to carry out effective governance and are inspired by concepts of foreign policy, and social justice. In short, in short, the government needs certain guidelines to frame law, which are mentioned in part IV of the Indian Constitution under the title Directive Principles of State Policy. The directive principle of state policy promotes the concepts of liberty, equality, justice. According to this live stream, we will discuss all of them and all the difference between all sections of law here in our Legal Eagle channel. Now, I will finish my live stream and we will meet soon in very strong videos here in our channel. Please subscribe in the channel and make comments, leave like, and we will meet soon. Thank you very much.